I measure the progress of a community by the degree of progress which women have achieved, said Dr. B.R. Ambedkar. With an intent to further strengthen the advancement of women's rights in India, numerous legislative documents have been promulgated. However, one such aspect that repeatedly dodged the attention of the lawmakers was the safety of women at workplace. Often it was observed that such cases of harassment were usually not reported owing to numerous reasons, like the unavailability of an effective forum, absence of effective legal safeguards, and hesitance on part of the victim's social background. Given such backdrop, it was only through the celebrated Vishaka judgment passed by the Honorable Supreme Court in 1997 that a safe working environment for women was ensured. The guidelines laid by this judgment were eventually transformed into the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013, passed in March 2013 to ensure the safety of women and bring the violators to justice.
As India celebrates its journey of 75 years of independence, Sansad TV also contributes to the said glorious voyage by dedicating a unique series titled 75 Years Laws That Shaped India, an exclusive program discussing and commending different laws that have been passed by the Parliament during these golden years. I'm your host Hemant Batra, back with another episode in that series. Today our focus will be on the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013, commonly referred to as the POSH Act, basically a short form of the expression Prevention of Sexual Harassment, a statute enacted to provide for measures to prevent sexual harassment of women and thereby provide a safe and dignified workplace for women. To talk about this landmark legislation, we have with us a very eminent panel of experts. We have with us Pinky Anand, Senior Advocate in the Supreme Court of India. She has also been the Additional Solicitor General of India. Though an expert in the constitutional law and several other laws, she has been a great champion of human rights. Welcome to the studios, Pinky.
Thank you.
And we also have amongst us Mohan Mishra, a highly accomplished senior bureaucrat. Earlier, he was Secretary with the Ministry of Women and Child Development and also Secretary of National Commission for Scheduled Castes in the Ministry of Social Justice and Empowerment. And at present, he is the Executive Chairman of Meghalaya's Investment Promotion Board. Welcome, Ram Mohanji. So, let us begin the discussion. And Pinky, let me come to you first. The statute, what we are discussing today, the POSH Act, as it is known as in short form, was enacted in 2013. But prior to this enactment also, there was a framework, a structure dealing with similar kind of offenses of sexual misconduct against women under a more stringent profile of law, that is Indian Penal Code, section 354 and 509. And thereafter, in 2013, another set of provisions were also inserted, 354A to D, which dealt with stalking, voyeurism, prying, and even, the sexual harassment scheme was strengthened. Then why there was a need to have this full-fledged act in the form of POSH Act?
Hemant, we are in the 21st century. And ultimately, I must share with you that I was part of this process which led to this legislation.
Oh, is it?
So, I was part of the committee which looked into the issues and how to deal with it.
Okay.
But having said that, why I said the 21st century? So, it is not good enough for you to have a law which puts people behind bars. So, basically, the penal code, as we all know it,
Absolutely.
section 354, which is sexual assault and today called sexual harassment, if you like, It was earlier called outraging the modesty of a woman.
Yes.
In fact, it was a very badly worded heading, I must say, and I'm glad it was changed around to sexual harassment. Dealt with conviction. 509 also, which is similar in the sense of sexually outraging the modesty of a woman, is also something which has penal consequences. So yes, you can be put behind bars if you've done something. But what do you need to create a safe environment? It can't only do with criminal laws, because that is for taking care of offence which has happened. What do you do for the current point of time? Can everybody go to a criminal law system? Can everybody go to a police officer and report a crime and say a crime has happened, now please punish the person? Mostly not. So the whole object of the POSH Act of 2013, of course POSH Act of 2013 came in that year, whereas 1997 Vishaka's guidelines were pretty much put into place by the Supreme Court, finding that there was no law. And the whole issue was of gender equality and, if you like, of affirmative gender equation, and to put women on the pedestal, because ultimately in this country today, women as equal citizens of the country are, even in terms of voting rights, you find that there's only 2% difference between women and men in today's day.
Right.
Mostly women are working, whether in formal sectors or informal sectors. Women are not comfortable by nature. In fact, people are not. I wouldn't even say women, but women more so, are not comfortable in nature to report a crime. Women want to work. What do you do to do that? So that purpose was achieved through Vishaka guidelines and ultimately by the POSH Act, to say, I am going to create this entire landscape for women to be able to work in a workplace, and that workplace, of course, has been widened, and we'll come to that, I'm sure, a little later, so that you can ultimately result into civil consequences. You can create a safe environment at the point the woman is working, therefore she can continue to work. She doesn't want to be out of work, she wants to continue working, but how does she achieve that? So that is the object with which the entire process is put into place. Within the POSH Act, for example, you have a committee. You have an internal committee which is comprised, of course, and headed by a woman, possibly a senior officer from the same company. The idea being that people may find it easier to go to an internal committee to report, which can actually go into the entire situation. This is a very subjective situation. It's not an objective situation.
Absolutely.
There is prescription under the Act. But to judge that, you need somebody to put into place. Can you have a police officer ultimately evaluate what is a physical contact that is unwelcoming? What is the physical contact that comes in the purview of sexual harassment, where it is not, let us say, something like extreme rape. Even within that, so much controversy has happened in the recent past. So the entire object of this act was to bring this forward, to provide all an encompassing remedy for a woman, and to allow her to continue in the same place and to hold her perpetrator at bay. Stop him there.
Absolutely, yes. That's a very valid argument which has been put across by Pinky. And as Pinky mentioned, Ramonji, that it finds its origin in a way in the Vishaka judgment, and obviously also Article 14, 15, 21, and even 19(1)(g) to some extent, and then obviously international conventions, etc. So as a public policy maker and even an administrator of public policy, how do you look at this particular statute? Its significance, and also as a landmark law, because many experts have labeled it, identified it as a landmark law that shaped India.
Hemant ji, just like Pinky ji has described in detail, one is it's a special law. It's not part of the general law stream. And the moment you have a special law, it brings special focus on that particular subject. And it also creates a special kind of arrangement of enforcement and also compliance. So this is one defining feature. Second is, this clearly defines the definitions of what is a sexual harassment.
Yes.
Otherwise, as she was saying, then generally people keep guessing kya hai sexual harassment, what is, it is not.
Absolutely.
So this is two. Third and most important thing is the redressal.
Yes.
Suppose you have a grievance or you have a complaint to make, then it's not only important to punish that person, the redressal. So here, like say you have a provision where it says that she can be given leave if the conditions are not very favorable.
Yes.
The person who was harassing can be transferred out if that person is a nuisance.
Yeah.
These are very important features of this legislation.
Yeah, at least when you are in that workplace scenario, I mean, putting somebody just behind the jail is not the remedy you are looking forward to.
You are looking for, and as you are saying, landscape.
Yes.
It's actually a complete ecosystem where you're housed. And more so, when you are having only an investigating agency coming from outside, that the support from within the organization many times is not that much forthcoming. It is an extraneous and outside element. Here it is mobilizing the complete organization setup itself.
Absolutely.
So this is a very kind of special feature of this kind of legislation.
Right.
And it becomes a very collective endeavor. And this is what is needed, because women, this issue is not only incident of harassment. It's a very complex, very vast issue which has to be addressed by us all in totality.
Pinky, I think stage is set to delve into the contents of the statute now. As you were mentioning, it's all-encompassing act. Definitely it is. It is a comprehensive law with 8 chapters, 30 sections, though it's not very detailed in language, but it's definitely comprehensive and all-encompassing. I definitely agree with you. And the central foundation or part of this act is sexual harassment. The title also talks about sexual harassment, prevention, prohibition. How does the act define sexual harassment, and who's an aggrieved person, or who could be an aggrieved person under the act?
See, Hemant, ultimately, as we've discussed earlier, this law was meant to be very wide. So, when we looked at the act and when we were looking at making the law, in fact, the idea was to ensure that each and every component of it is included within the parameters of the law, of the POSH Act 2013. The idea being that any action should not go past. And as I said, you've seen from past experiences that some other laws have required a lot of interpretation by the courts, and some explanations or some determinations have even been looked at rather scathingly by the Supreme Court and by other jurisdictions, because ultimately what you have as a sexual advance, let's say, or sexual assault or sexual harassment at workplace, it's a wide word. So would it include only physical? No. It does include physical, of course. And does it require only physical contact? No. It doesn't. Asking for sexual favors. So, it starts with physical contact as the first and foremost. But even that, incidentally, jurisdictions have held that what kind of physical contact would amount to sexual harassment is something which needs an assessment.
Absolutely.
That's why I say the Act does leave some subjectivity, and it has to. Yes. Because one action may be regular and one action may be not be regular. Of course, some actions are beyond that, and they come clearly within the category
because as you said that when the definitions are wide, it has to be subjective.
That's right.
That is an sort of integral component of such a definition when the definition has a wide import. So you rightly said.
So the thing is, for example, the two broad principles also include sexual favors quid pro quo. So if you ask something for a favor, saying I will give you this in return if you promise me sexual favors from your side.
So
that also amounts to that. An unsafe, hostile environment. And that hostile environment again has to be adjudged, but hostile environment where it's difficult for a woman to work. Because either, for example, let me give you an example. For example, you're asked to attend overnight parties or to go out of station, that too frequently. And in fact, it's been dealt with some cases also. So this hostile working environment is something which essentially forms the sum and substance of sexual harassment, starting from physical contact and physical attack, physical assault, literally, beyond that to asking for sexual favors, looking unwelcomingly or looking hostilely or looking in a manner which is, therefore you said voyeurism. Now, if you take that in a broad category, these are the same environments, excepting one has criminal law repercussions and one has these repercussions whereby you have a safe environment to work in.
Absolutely. It's like quasi-criminal or civil.
Yes, and it can lead. Ultimately, the recommendations of the internal committee can lead to disciplinary action as much as action may be initiated by the police based upon the recommendations of the committee, which it can do and should do. Frankly, there's no reason not to.
Absolutely.
But each of these situations which covers, as I said, from physical to non-physical, even emotional harassment, because of gender equation, that is the basis of the entire situation to say this is what is called sexual harassment.
Right. Well, the need for formulating an effective mechanism was long felt to address the widespread underlying discrimination and prejudices being faced by the women in our country. Women have been at the forefront of many successful ventures, be it commercial, official, charitable, sports, or promotional or services sector. Hence, it was imperative that the Parliament provided for a legal mechanism ensuring a conducive and secure working environment for them. So let us have a look at the legislative trail of this act.
The Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Bill 2010 was tabled before the Lok Sabha on December 7, 2010 and was subsequently referred to the Parliamentary Standing Committee on Human Resource Development on December 30, 2010. The committee, after much deliberation, submitted its report on December 8, 2011. Thereafter, the Lok Sabha passed the bill on September 3, 2012 and the same was passed by the Rajya Sabha on February 26, 2013. The bill, along with some of the proposed amendments, was finally passed by the Lok Sabha on March 11, 2013. It received the presidential assent on April 23, 2013 and was subsequently notified on December 9, 2013. Let us view and hear some of the interesting points being raised in the Parliament on the said Act.
I beg to move to leave to introduce a bill provide protection against sexual harassment of women at workplace and for the prevention and redressal of complaints of sexual harassment and for matters connected therewith or incidental thereto. महोदय, मैं आपके निमित्त से सदन में कार्यस्थल पर यौन उत्पीड़न में महिलाओं को संरक्षण विधेयक 2010 प्रस्तुत कर रही हूँ। कृपया इसको पास I also move that amendment made by Rajya Sabha be agreed to.
The question is that the amendment numbers 1 and 2 made by Rajya Sabha in the bill as passed by Lok Sabha be agreed to. Those in favor may say aye. Aye. Those against may say no. I think the ayes have it. The ayes have it. The motion is adopted and the amendments made by Rajya Sabha in the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Bill 2012 as passed by Lok Sabha are agreed to by the House.
So let us carry forward our discussion. Let me come to you, Ram Mohan ji. Earlier we were discussing about the Vishaka judgment, of 1997. That is a stepping stone judgment. Pinky also mentioned about that. So it's very important for our viewers to understand that what significance this judgment holds in the legislative landscape, especially in respect of women's rights. Could you tell our viewers about that judgment?
Actually, as we were discussing, this created a watershed in this entire domain. And as we know in Rajasthan that Bhawna Devi,
yes,
she became the victim because she was protesting against these child marriages. And the very men who were affected by her endeavors, she was gang
She was an NGO activist or something?
Yeah, she was Sathin, as they call it in Rajasthan. And then she was gang raped by the same men who were hostile to the work she was doing.
I see.
And taking cognizance of this, a PIL was filed in Supreme Court. And Honorable Supreme Court took cognizance of the entire matter and then provided path-breaking kind of legally binding guidelines. Generally, guidelines are issued, but these are legally binding guidelines. Nobody had the choice to do or not to do in terms of compliance and implementation. So this is where this judgment catalyzed, I would say paved the way for this legislation which we are just talking about. And it flows from Constitution. As you were mentioning, Article 14, right to equality. Women have to be treated equally. Then dignity, liberty, and then right to work. So all these are kind of impacted by this harassment of whatever kind, particularly sexual harassment. And the dignity of women is affected, the liberty is affected, the right to work is affected. So the constitutional rights, which are fundamental rights. So Honorable Supreme Court based this entire decision on the principles of fundamental rights. It was not only women's rights actually, we say it's a fundamental right.
Enforcement of fundamental rights of women in a way.
So this act is not one more right, providing one more right, creating one more right of people who are covered here. It is coming out of fundamental right of citizens, particularly women. And this is where this judgment paved the way for this act, as I said. And this act again has so many provisions, as Pinky ji was saying, and particularly the provisions regarding the social, the rehabilitation part of the woman. Those have been really very, very interesting. So this is what I would say is the.
Well, वो कहते हैं देर आए दुरुस्त आए. It took more than a decade and a half to kind of pass this law, which was mandated by the judgment.
I'll add something to what Ram Mohan ji said here, since we are conversing on the subject and the impact it had. Yeah. What was most amazing about Vishaka, in addition to what Ram Mohan ji said about fundamental rights and the fact that Supreme Court looked into it, is something that this is one of the judgments we cite day in and day out when we talk about a vacuum in legislation. When there is no law in the country which is covering an aspect which needs to be covered.
Absolutely.
And the forward-looking and the pragmatic approach of the Supreme Court to actually take from the fundamental rights which was already there, nothing which was invented, so to say, or created as it's a new right, a new law, but constitutionally it was there. The even more important part was international conventions and our commitments, for example, to CEDAW. That was taken into account when, putting down these guidelines. And frankly, Ramonji is right. In a sense, if 2013 POSH Act had possibly not even come into place, it was already in place in 1997, because Article 142 of the Constitution binds the country.
Yes.
And binds everybody and every citizen within it. Yes. So therefore, these are binding guidelines. But in order to put together a structure, an institutional framework where women could actually engage themselves and ensure that others disengage themselves from unwelcome activities, which would ultimately create a difficulty in their working environment, is something which led the way forward. And when you mark an act, even more important is one more fact. When you put an act into place, and especially at that time, in fact today several more laws have come into place to ensure this affirmative action as far as women are concerned, but that was one of the starting points.
Yes.
So you had from the normal domestic forefront, though domestic forefront is also covered here, for a working woman in the sense of an employee. So a domestic worker is covered under the Act. But you actually had putting into place a situation for covering the entirety of the problems. And therefore the step forward into marking that the world acknowledge that India will not tolerate any kind of negative action or unwelcome action or hostile action where women cannot perform to the best of their abilities and give to the country themselves as they are giving. So therefore that recognition is very important as a narrative in law.
Absolutely.
You enforce that.
Absolutely. And Pinky, as we were discussing some key statutory provisions, our viewers would like to know the wider import of some key terms which have been used under the definition clause. For instance, domestic worker, employee, employer, workplace. If briefly, if you could give an overview about these terms.
Actually, let's start straight away from aggrieved person. In fact, you asked me a question and I got left.
About aggrieved.
So, aggrieved person actually again has been widely imported into not only people who are working, but people who come into the workplace. And that's one part where I remember that we played a fairly important role in making that all-encompassing. So, for example, in a workplace, it is any person. So, it is not confined to a person who is an employee. And I'll come to the employee part. So, therefore, it includes, for example, a person who comes into the office for engaging in some exercise, for giving in papers, for pitching her job, for example, for future. So, anybody who visits a workplace is also included within the definition of somebody. So, aggrieved person actually has been made, aggrieved woman rather, has been made into this categorization, which includes each and every person who enters the workplace, not only is engaged in active employment, but anybody who comes there and is covered by this provision. So, therefore, you have coverage. For a domestic environment, however, it is covered to an employee. So, somebody who is actually working there. So, coming to this entire position, that is the manner in which you take into its circumference. Because the idea being is not confined to X or Y category. The idea is to make it all-encompassing. So, an employee would cover any employee, temporary, permanent, ad hoc, transitory. It covers each and every category. It covers each and every sector. It covers the formal sector. It covers the informal sector. Employer is person who is engaged in the management, supervision, in the running of an establishment. So, therefore, again, it means anybody who is there in an overall supervisory kind of capacity who would be there and represented as an employer. The other definitions also, each of them go towards this aid. So, this entire relationship in a workplace and the workplace itself has been defined to be any place. It includes hospitals, it includes airports, it includes government, it includes private, it includes
both government
companies.
And private establishments are covered.
Yes, each and every part of this establishments are covered. So there is almost nothing which doesn't come. And as I said, the maximum discussion when framing this act was on the workplace. Because the minute you made the workplace a wide gamut, then it intruded within the place. I mean, for example, even a TV studio where you're coming in for work would be included in such a purview. Absolutely. And that was the idea, that you would be safe in any environment, not only in what is technically called an office, and technically where you're an employee, and technically where somebody is your, let us say, the executive director or somebody in that position. Any supervisory position, any working position, any visiting position, anybody coming into that workplace is covered, and therefore what is even more important is the domestic staff too. You have coverage of the domestic staff
as well
within the purview of the Act.
Okay, that's a very wide definition, to say so, and obviously that's why it is subjective as well. Well, we'll be slipping into a very short break. Please stay with us, as we'll be back soon. Welcome back after the break. You're watching our special show on 75 years of legislative journey. Today we are discussing another extremely significant law passed by the Parliament to keep up with the changing times. We are talking about the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013. An impressive statute that genuinely attempts to ensure safe and equitable working space for women. Let us now also see the international scenario which influenced the POSH Act and other prevalent mechanisms around the world.
Prior to POSH Act, India ratified the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, in July 1993. Defined as the Women's Bill of Rights, CEDAW has been ratified or signed by 189 member nations of the UN. Even the landmark Vishaka judgment of 1997, passed by the Supreme Court of India, was inspired by the CEDAW principles. It defined the terms sexual harassment and further codified preventive measures as well as in-house redressal mechanisms to be formulated by the employers. In other jurisdictions like the European Union, the USA and the UK, the sexual harassment is treated as a species of illegal employment discrimination. This is also inclusive of the employer-employee relationship as well as an adverse working environment. Another key development in the Indian context also took place in 2017, when a notable step was taken by the Ministry of Women and Child Development through the launching of the Sexual Harassment Electronic Box, popularly known as She-Box, an online platform for the filing of the complaints by the victims.
So let us proceed with the discussion. Pinky, there are several laws with regard to harassment and misconduct at the workplace globally, And to my understanding, if we were to talk about the developed nations, there the laws are gender neutral, whereas the POSH Act is gender specific, dealing with feminine gender. So how would you like to respond to that particular aspect of distinction?
Well, that's a subject of immense debate. I mean, why not have a law that is gender neutral? Because ultimately, if something can happen that disrupts, let us say, the working environment or a human dignity aspect, why should it not apply? But generally, the history of this country has been such that we have been looking at gender as an issue. And gender has been, that is, women have been more subjected to harassment of various kinds, whether it's domestic, whether it is family, matrimonial, whether it's physical, whether it's emotional. And therefore, you have various acts like the Domestic Violence Act coming into place. You've had issue of property being discussed and debated upon and laws being changed. So the focus generally has been that of addressing the rights of women in this sexual harassment issue. But I guess times are always there for it to be considered on other aspects. And we have had laws, for example, POXO is a gender neutral law.
It's gender neutral,
so therefore, when you have a question of sexual harassment of boys versus girls, or boys and girls rather, better put like that, you do have a law that addresses that issue. Therefore, this discussion is something that has to happen. Right. But the need of the hour at that point, and possibly continues to be as such for the time being, is something that requires it to be addressed to women. And I do think, as Ramonji was saying ultimately, that you do require a time when you need to address a issue.
Yes.
And to focus and to put the landscape in that perspective. Right. So maybe we do need to come up with something either further or to translate this law, because you had several situations where she includes he or he includes she is something that has been the subject of discussion, for example, under the Domestic Violence Act.
Right.
I was member to a case, rather, I was a lawyer in a case where this whole interpretation in the Domestic Violence Act is something that had come into being. So therefore the harassment could be by he or a she, or and it would make a difference, and ultimately something that should come within that. So, yes. Secondly, there is something that needs to be also thought about, which is the LGBT community.
Yes,
and
correct.
that I think has been subject matter of a Calcutta High Court decision also, that it should be looked into. Absolutely. And it should be considered.
Absolutely.
So you have, and you have other laws also at the Supreme Court having decided that you must have attention being paid to the LGBT community and to ensure that they are brought back into, again, that same human dignity surface.
Absolutely.
So these are issues that we do need to take up, but we have taken up the issue which possibly required the most urgent redressal at that point of time, and we continue for the time being to function on that. And incidentally, even now there are some glitches. I mean, all said and done. For example, the law requires setting up of committees, but have all committees been set up?
Yes.
Have they been set up right from the top to the bottom?
Right.
Have they been set up in the government institutions? Forget the non-governmental institutions.
Right.
Have they been set up in listed companies? Are people approaching them as much as they should?
Right.
Because ultimately, you find, for example, complaints are somewhat nominal even now.
Right.
So there, no company, for example, has reported more than 50 complaints as an overall basis. So everything is under that number. I am not saying reporting should be higher. Let us not mix that subject up. But the point is, there should be belief in the system, and therefore belief in the system is reflected by people approaching the system.
Absolutely. So Pinky brought up this issue of committees, whether committees have been set up or not, which are the backbone of the Act. Ramonji, there are specific provisions about the internal complaints committee, the local complaints committee. Can you tell our viewers about the constitution and composition of these committees, and what responsibilities are cast upon the district officers, in that regard?
These internal complaints committees are in all the establishments which imply more than 10 people. So this is mandatory for them to constitute. And they are in various stages. Some have constituted, some are in the process of constituting, some have not constituted. So these need to be strictly enforced, because these are very, very mandated by Supreme Court as well as law also. So this is one. The committee has to have a very senior officer who has to be a woman compulsorily.
I see.
As the chairperson. So this is an important point. Second, then 2 other employees, the organization. And then this non-government organization, 1 person should be there. And one must be having a legal kind of background, a legal understanding out of this. So these committees are to be constituted everywhere, and then less than 10 people. Like say, if you see employment of women, mostly it is in informal sector, whether it is domestic workers or it is informal workplaces and so forth. So this is where I think maximum problem. And this onus of tackling this problem is on the district officer and those local committees.
Yeah, so if there is any complaint which has to be brought about by a domestic help.
So less than 10 people.
Less than 10 people. So she has to go to the...
she has to approach this...
local, because there is no internal complaints committee.
There is no internal complaints committee.
Local complaints
so the district officer means district magistrate, that means the collector. It includes a district magistrate, additional collector, and also deputy collector.
Oh.
And in this, the district administration has to have the nodal officers for the better reach and access at the block level and the tehsil level and so forth. Here again, the local committee has to be headed by a woman, has to be a kind of social worker or coming from the background, having commitment to issues of women. Then representatives from non-government organizations. Then the women and child development officer of the district has to be ex officio member there. And here again, scheduled caste, scheduled tribe, obviously this one person has to be representing them.
I see.
One of these people have to be having legal background to facilitate even the technical dimensions of the proceedings, because it's a quasi-judicial, as you said, proceeding. So if you don't understand law, and particularly the process part of it, There could be problems, there could be mistakes.
Right.
So this is how it works. Most important responsibility has been given to the district collector here, because the majority of people fall in that informal sector.
Right.
Where this, as Pinky ji was saying, the mechanism to enforce the law and the number of people approaching the system.
Yeah. But
Sometimes
is it publicized? Well publicized? I mean, are people sensitized? Is there awareness amongst the general public about that there is this district officer who's ready to receive your complaints?
There have been efforts. I mean, I remember when in the ministry, there are efforts continuously made to issue the circulars and then to hold the seminars and workshops and all that. But of course, I think it needs to be improved. It has to be better awareness of the provisions and how people can access. Not only that, people who approach the system for redressal, a lot of hand-holding is required. Because not only they have a grievance, but they also are going through trauma.
Right.
And therefore, that psychosocial support.
So that's why there is involvement of NGOs and representative of NGOs in the committees, perhaps.
Yes.
Pinky, Chapter 4 and 5 are also very fundamental. They deal with the procedure of filing complaints and inquiry and the possible outcome. Can you tell our viewers about the scheme of how the complaints are filed and how it proceeds further?
No, you're right. In order to be able to have a system work effectively, you need to have a system which is transparent and something which is efficient.
Right.
Because that is what you need. So you actually have a time disposal for the complaint to be decided by the committees, whether it's the internal committee or it is the local committee, whatever the case may be, which makes it 2 months for decision. You have a time limit for filing the complaint, incidentally. But it is subject to extension if the internal committee so desires that it can be done. So the whole action is initiated by a complaint filed by the aggrieved person. That complaint may be filed by anybody, by the aggrieved person themselves or by some other person on their behalf if she is unable to approach the system or the committee which it is there. Once the committee is seized of the matter, the complaint, the committee looks into the matter, engages into discussion. It's also a system of mediation and conciliation, which is there for in order to see what can be done to alleviate the entire problem through the committee's mechanism. On the committee coming to a finding, action is taken on the basis of that finding. So action which is recommended can be any kind of action which is available under the civil law. So therefore disciplinary action which is available under the civil rules, whether it's censure, whether it is warning, whether it is termination of service, whichever of the features it is, the committee can ultimately recommend that. As far as the committee is concerned, it can also recommend any criminal action to be taken, but that of course has to go to the criminal machinery for in order to work. So the police has to basically take it over and then take action on that basis. You can have a provision as interim, for example, provision. There is provision for granting leave. There is a provision for transfer of the person who is perpetrating. There is provision for compensation, which can be given based upon the entire features which is there available for compensation, mental agony, the harassment, work lost, as far as the woman is concerned. So each of these aspects is taken into consideration by the committees, and the committees come to their finding. And as you see, basically you have each of the provisions for punishment in a civil mode of action, which can be taken up and will be taken up and shall be taken up.
Right. Ramonji, coming to you again in your capacity as a public policy expert, do you think that some steps are still required to make this law more effective? And though this law has been there only for 8 years, and we have so many other laws which have been there for decades, so it's a fairly young law, but still, do you think that it may still sort of require some amendments and changes at this stage? What is your take?
It has two parts. I'll divide it into 2 parts. One is the legislation per se. Now, this harassment and all these problems emanate from a larger context of gender development, gender inequality, the power kind of context and scenario, power imbalance. So therefore, this act has to be seen in the context of all other acts which Pinky ji was mentioning earlier, which empower the women, which give them strength and then that robust kind of institutional frame to be as they are and also to experience that liberty, equality and dignity. So this is one thing which maybe the law has to be having little more coordinating kind of context. I don't know whether it should be in this law or there should be some other mechanism. So this is one thing which is required. The second thing is, as I said, there is a tremendous social and psychological context to this law.
Absolutely.
And therefore, when, say, she was talking about complaints, right, and there is a provision of, say, compounding kind of thing, as you said, consensus and all that. So there, one thing as a society, we have to make sure that there should be zero tolerance to this harassment. And it has to come from society. Because the policing from outside is one part of policing. And the second part of the related policing is community policing, with effort has been made in this law. Third is internal policing. When I was growing as a child, Hemantji, my grandmother told me this, that on your shoulders, on one side you have Chitraveer, on other shoulder you have Vichitraveer. So they are writing a scroll of your life, not only what you do,
Right.
but also what you think.
Right.
So mensaria generally alone is not punishable.
Absolutely.
But in our traditional system of culture, even mensaria was punishable. By whom? By some system where it will be thwarted and you will have to pay the price for it. So this entire attitude, sanskar as we call it. So therefore, when you talk about change, say district officer is also heading the administration for development.
Right.
So the entire issue of education, when the child is going, say, person who is going to harass, potential harasser in due course. If the internal policing mechanism, the moral policing within that individual is made robust and strong enough in the very childhood itself, and बाद में जब वो बड़ा हो, तो कहे भाई जिसकी ये बहन बेटी जिसकी किसी के है, उसको अगर मैं इस तरह का कर रहा हूँ, तो मेरी बहन बेटियां भी तो हैं. और ऐसा मुझे कैसा लगता अगर मैं खुद औरत होती, तो मुझे कैसा लगता. तो ये जो संस्कार डाले जाते हैं, मैं समझता हूँ कि ये लॉ में या पॉलिसीज़ में या उनके इम्प्लीमेंटेशन में कहीं ना कहीं इस चीज़ को लाने की ज़रूरत है. और इसका एफर्ट रहा है सरकार की तरफ से, एफर्ट रहा है कि उसको सबको इंटीग्रेटेड अप्रोच. तो आज आपने अखबारों में देखा होगा यूपी गवर्नमेंट ने मिशन शक्ति वहाँ पे एक चलाया, जिसमें सिक्योरिटी, डिग्निटी एंड एम्पावरमेंट की बात हो रही. जब मैं मंत्रालय में था तो हमारी माननीय मंत्री जी का एक बहुत बड़ा है, उनका एक सपना था कि हमारा एक मिशन शक्ति चले यहाँ पे नेशनल लेवल पे, which should be about the same thing, security, safety, dignity and empowerment of women. So until unless we address the issue of gender in a national context and social context, this problem will remain complicated, and therefore we need to work very hard, and some very good measures have been taken. So we need to just maybe further consolidate.
So these are very valuable suggestions, what you have just rendered. Well, it's time to take viewers' question. And the question has come from Sri Lakshmi from Noida. Let's listen in.
The Act provides for action against a woman for false complaint. Don't you think that this will discourage the victim to come forward with their complaints because the dominant party can label a complaint as false?
Pinky, would you like to take this question?
Again, this question, Sri Lakshmi, has been the subject of immense debate. Should you ensure that the law is able to take action the way it is and not be initiated on the basis of false complaints, or should you give this larger protection to women so that even if it's a false complaint, people should not be prosecuted? I'm afraid there's no clear-cut answer on this. The narrative is very clear. By the way, it is not considered to be false and malicious if you are unable to support your complaint, or if there is not adequate proof. That is safeguarded under the law. What is ultimately censured or punishment is provided for is a case where there is a false complaint. And frankly, to some extent, we do need to save the system, because you do have false complaints, and increasingly you're finding this running across the surface of women laws, so to say, that they are being misutilized. So while we protect women, we should ensure that any other section of society also is not persecuted. The fear of having this position and this provision in law is to ensure that the system is not misutilized. Because it's easy to say, let a complaint happen, let women not be persecuted. But what happens if some man's reputation is at stake on account of a false complaint? Absolutely. So at least you should have the fear of God and the fear of law in you to say, I will not initiate a false complaint because I may get prosecuted. And whether you will ultimately get prosecuted or not, because for prosecution, incidentally, an intent also must be there, a false intent, not only an action, but an intent to have a false action.
Right.
So I think there is reasonable protection, and you have the exclusions of normally what happens in a complaint is a complaint doesn't go forward when there isn't sufficient proof or there isn't any proof. So the matter gets dropped because you're unable to prove your case. So that is not false, so that is protected.
Yes, that's a very fundamental point. But where if somebody is unable to prove, that does not automatically get branded as a false or a malicious complaint. So it has to...
That is the manner in which, Hemant, the whole idea is to ensure, because there will be a number of cases. You will find that across board for women's cases, that you will not have sufficient proof. There will be only, at best, a circumstantial proof, and it may not be sufficient to prove the case. What happens?
So it has to be equitable in that sense. Well, by and large, this law of preventing sexual harassment of women at workplace has brought into light the long neglected issue of women's safety at workplace. It has addressed several crucial inadequacies of the past, and with its further progression, it will definitely cope up with the existing challenges. On that note, we come to the conclusion of this episode. Thank you so much, Pinky, Anand, and Mohan Mishra, for giving us deep insight about this law and even the issues, surrounding around it. Thank you so much. Well, that's all we have in this edition of the program. You can send us your feedback at sansad.tv@sansad.nic.in. You can also connect with us on various other social media platforms. Thank you for watching. Goodbye and Happy New Year.